And so that's where having an attorney can be helpful. There are some inexpensive and free legal services that are available to assist you with this if you need certain qualifications. Basically, what we're trying to do is help avoid problems going down the road, because the issue is that the executor or administrator can be personally liable for things if they don't do things properly. So that's why just kind of a warning. Okay. So if a person died, we hear these terms testate or intestate. Testate means they died with a last will and testament. That is your testamentary document. The will is normally going to name an executor who will be responsible for going through the process and control the distribution of the decedent's property. If a person died intestate and they died without a will, the family members or the decedent's next of kin have the right to serve as administrators of the estate and be responsible for the estate administration. And who gets appointed as the administrator of the estate depends on their relationship to the deceased. Usually we're going to be looking for a spouse or adult children. If we don't have any of those, we might be looking for parents or siblings, or eventually potentially nieces and nephews. So people who are going to serve as administrators, normally they need to have the ability to serve, so they have to, and they'd be willing to do it. So if you had a family where there were 4 children, there was no will, the 4 children could serve, but let's say one of them was, had mental health issues, or perhaps was in jail or something, they would not be competent to serve. And let's say the other 2 of the other children didn't really want to do the job because they live far away, then maybe the one in Pittsburgh is the one who they will sign renunciations for and say, look, we're all willing to have Bobby do it. He's in Pittsburgh, we trust Bobby, and he can take care of us. However, if people don't want to renounce their right to serve, then you could eventually have 4 administrators. It just makes it a little more difficult and a little more time consuming to get that. When a person dies in estate, state law determines how the property is distributed. So it may not be the way the decedent would want it, but that's what state law says. Okay. All right. Okay, so we've talked about who the executor is, the person named in the will, or the decedent's next of kin if there is no will. To probate a will, you need the original document. If you cannot find the original document, it is still possible to sometimes file a copy of the will, but you have to meet certain criteria and you have to petition the Register of Wills office to do so. You need to have a death certificate. You need to have an estate information sheet, which we're going to show you. You file a petition for grant of letters. There is a fee to probate an estate. And you have to have a photo ID if you're going to be sworn in so that you can prove that you in fact are the right person. You do this in person, usually down at the Register of Wills office in the city county building, or whatever county the decedent would reside in at the time of their death. Sometimes you can mail in the documents, and there are rules about virtual probate, which is mean you're doing it on a Zoom call or Microsoft Teams, but that's going to depend on the particular county that you're trying to open the estate in. Not all counties have virtual probate. Some you just have to be able to go there. There are fees for filing the will or getting letters granted. And when do you do this? Usually you tell people as soon after the decedent's death as you can, but right now in Allegheny County, for example, it usually takes about 2 weeks before you can even get the death certificate. So you cannot open the estate without the death certificate. You used to be able to go in and say somebody died, but now you have to prove that they died. So that's why you need the death certificate. Okay. All right. A certified copy of the death certificate, and usually if you were involved, this is your spouse, this is your parent, you would get that from the funeral home. And basically what they're looking for is, they have you go and get sworn in, you raise your right hand and say that you will discharge the duties of your office in accordance with the laws of the Commonwealth of Pennsylvania. And then the clerk behind the counter, now that they've sworn you in, has you sign the documents, and they can then open the estate. Normally right now in Allegheny County, if you're opening an estate, we don't really have a lot of information about what the assets are. Most of the time, it's gonna be about $200.25. You always want that 25 cents. The different counties will be cheaper than ours. Okay. So here is this estate information sheet. This is like a cover sheet, and basically it's used for both testate and intestate estates. It's completed by the executor or the next of kin. It's providing information to the court, to the register of wills, about the decedent, about the family members, addresses, names. And you can go as a statewide form. It's used in all Pennsylvania counties, and you can find that online at the Unified Judicial System of Pennsylvania. And we give you this address. It shows up a number of times, so you don't have to write it down. It's on the slides. Okay. All right. Now the next thing that's very important is you have this petition for grant of letters. It's a 2-page form. And you have to fill this out because what you're trying to do is tell the Register of Wills office something about the decedent, as well as about the family member. You're indicating where the decedent died, that information you get on the death certificate. And if you have an idea that, well, the only thing they have is this house, you could put the address of the house and the value of the property. And again, this is another statewide. On the second page, this is where the address of the executor or administrator goes. And this is where it gets signed and where you indicate, how many short certificates, and I'm going to tell you what that is in a minute. Okay. So, after you're sworn in, and then letters are issued, letters testamentary if there's a last will and testament, or letters of administration if there is not. And basically this, yes, is signed by the Register of Wills or one of the clerks, and they put a nice seal on it so it looks very official. And usually when you have letters testamentary, your copy of the will be attached to that so that people can see it. Letters of administration are the same, but there is no will. It's still signed by the Register of Wills. And a short certificate is actually what you as an administrator or an executor show people to prove that you have the authority to act as the executor or administrator. It used to actually be a short piece of paper, which is where it got the name short certificate. Right now, it's a regular sized piece of paper because, of course, everything's done on computers, but it's still called a short certificate. You can also think of it as a short form of proof that you are the person in charge of the estate. So a lot of times after someone dies, people will call me up because they've gone to the bank and they said to the bank, we want to close out Dad's account. And the bank says, well, you need a short certificate. And they call up and they want to get a short certificate. And the only way to get that is to open the estate. You can't just get a short certificate unless you actually open the estate. So that's what I always tell people. So just so you're aware. Okay. Now, with the will, okay, I want to tell you this as well. Now, a will in Pennsylvania has to have 2 witnesses. Okay. People in Pennsylvania can still file what are called holographic wills, but then which means a handwritten will. If I'm sitting at home and I'm leaving on vacation tomorrow morning and I want to make sure that my children get everything, I could write a handwritten will. And they would have to go in and show that there were 2 witnesses who could say, yes, we didn't see Mom sign this, but we recognize that that is Mom's signature. If a will is notarized, in addition to having the 2 witnesses, it is called self-proving. So you do not have to have affidavits from the witnesses or sworn statements from the witnesses. It proves because it's been notarized as well as witnessed. So I tell people this because it is helpful to have your will notarized if you're going to have it executed. Okay. So once we've gotten the estate open because our executor or administrator is sworn in, they're going to have to do certain things. So they're going to have to collect assets of the decedent. You're going to have to pay debts, taxes. You're going to open an estate checking account and eventually down the line, distribute assets to the heirs or beneficiaries of the estates. So with that short certificate and usually death certificate, you could go to a bank and close out the decedent's bank accounts, collect their mail, go to the post office, change the mailing address, all sorts of things. So here's some of the things that the executor or administrator has to do. They have to provide notice to the beneficiaries and heirs of the estate. Why? Because these are the people who may inherit something and you need to tell them so. Years ago, you were not required to do so, but now you are, and you have to file a certification that you have given notice to them. You have to advertise in the state. It goes in the Pittsburgh Legal Journal if you're here in Allegheny County, as well as in a paper of general circulation, such as the Post Gazette. any other paper that is around here. All right, the executor or administrator has to identify and collect assets. So you might look through the mail of the decedent and find that they had a bank account at this bank or that bank, that they had a brokerage account. You might be going through their house and find savings bonds. Now, we need to open an estate account. Why? Because you have to think of an estate as a business. It's a small business and you have to have a way to be able to deposit its money and to pay its bills. So you need to open an estate account. And to do that, you also need to get an employer's identification number or an EIN number, because you cannot use the decedent's social security number after they have died. So this is a separate bank account that will only hold the money belonging to the estate. It will pay bills. It could do all the things that it needs to do. Eventually, you have to file an inheritance tax return in Pennsylvania. We can talk a little more about that. There are income tax returns, the decedent's final return, and then a fiduciary income tax return potentially for the estate, if the estate earned income or sold real estate, things like that. And you also have to file an inventory. And an inventory lists the assets, the probate assets of the estate. The executor or administrator has to pay the decedent's debts and eventually distribute assets, including real property. And once everything is done, then we can close the estate. And most estates will take anywhere between 15 to 24 months. It's kind of the usual time frame. So the executor or administrator has to determine who the beneficiaries or heirs. Beneficiaries are going to be those named in the decedent's will. All right, they could also be a named beneficiary on a life insurance policy or a retirement account. Heirs are those who inherit under state law. So it's important to note that state law may not always distribute property the way the decedent wants them to be distributed. So, for example, if a person, a married couple, and they had 2 children, if one of the spouses died without a will under Pennsylvania law, then the estate split between the spouse and the children. Whereas the deceased spouse may have wanted everything to go to their living spouse, but since they didn't have the will, that's not what's going to happen. Okay? And it also makes a difference if it's their children together, or it's a second marriage and the children are from the first marriage and the spouse is the second spouse. So it's just kind of interesting to note. All right, we reference here sending the notice of estate administration to the beneficiary, and it must be sent within 60 days of when the estate was opened. Okay. It doesn't mean they'll get anything, because the estate may not have enough money, but they have to tell them. And you file a certificate of notice with the Register of Wills, and then the estate is advertised, which I talked about that. And right now, the advertising is somewhere around $260 to $270 in Allegheny. This is a copy of the notice of administration and certification. So these forms again are in the material so that we can see them. All right, this is identifying the assets, making a list of assets. It used to be that it was easy enough because you could go through people's mail and you could find information about what their assets are. Now it's a little harder because many people have online accounts. They pay bills online, so it can make things a little more challenging. Okay. And this talks about determining the date of death value. In Pennsylvania, we have an inheritance tax, and the tax is based on the value of the house or the assets as of the date of death. So that's something that needs to be obtained. All right. And I talked here about this EIN number, and it has to be obtained, the employer identification number. But it's important to note that there are fraudulent sites that will issue these numbers and they charge you for them. If you do it through the regular Internal Revenue Service site, there is no charge for obtaining the EIN. I think that's helpful to know. You're going to close the decedent's accounts and deposit the funds into the estate checking. And eventually you will complete an inventory and file 2 copies with the Registry of Wills. This is usually done within 9 months after the date of the decedent's death. Usually at the same time we file our Pennsylvania inheritance tax return, which is due 9 months after the decedent died. Okay. And the inventory form lists all the date of death values for the probate assets. So that might be a house, it might be the checking account, It will not include things as joint accounts or things with named beneficiaries. These are only probate assets that go on the inventory. It's signed by the executor or administrator and filed in the Register of Wills office. 2 copies. Okay. Now, let's take a little bit and talk about taxes. Unfortunately, you cannot avoid death and you cannot avoid taxes. So, all right. So if the decedent, somebody passed away in 2025, they might be a final income tax return that would need to be done for them. And that would be done normally starting in 2026, because that's when the tax forms come out. Now let's talk about Pennsylvania inheritance tax. Okay, so the tax rate that has to be paid for Pennsylvania inheritance tax depends on the decedent's relationship to the individual. So for spouses, the tax rate is 0. Those spouses do not have to pay inheritance tax. Direct descendants, lineal descendants, parents, children, grandchildren, anybody in that line, those direct descendants, it's a 4.5% tax. Now, in 2019, the Pennsylvania legislature was kind enough to pass a law that said if children are under 21 and the person dies after January 1st of 2020, there's no inheritance tax. It's a 0 tax rate for children, which is very nice because children had to pay taxes for years. Siblings, brothers and sisters, they pay a 12% inheritance tax rate. Everyone else pays a 15% tax rate. So that's your friend. If I'm leaving anything to Nina, she paid 15% rate. Charities do not pay any inheritance taxes. They actually help save inheritance taxes. Taxes are due within 9 months of the decedent's date of death. But the Pennsylvania Department of Revenue was very nice, and they said if you pay the inheritance taxes within 90 days of the person's date of death, or basically 3 months, you can save 5% of the tax. So if the tax amount owed is $10,000, you could save $500. Okay, it doesn't change the rate; it just gives you a discount on the amount that's due. Inheritance taxes are usually paid out of the estate. However, if you have a will, you could indicate that the beneficiaries of the retirement accounts for the beneficiaries of the joint accounts have to pay their own inheritance taxes, and then the estate won't pay them. Okay, what people inherit from the estate is usually not taxable income. It's usually considered principal. Okay, unless it's some kind of a retirement account, like a traditional IRA or a 401k or something like that. Those are subject to income tax. All right, now let's talk about the decedent's debts. Well, normally you're going to have funeral expenses. And that can include anything from the money going to the funeral home or the cemetery for grave opening and closing, the funeral luncheon. You know, you could go to McDonald's or you could go to Ruth's Chris. So it depends on what kind of lunch you can afford and want to have. But, you know, it's one of those things. Okay. All right.
You're muted. Oh, thank God.
Okay. There might be income taxes that need to be paid from the decedent, outstanding bills. They could be medical bills, credit card bills, all sorts of expenses that are paid out of the estate. But sometimes an estate is considered insolvent. It has less money than it has bills. Okay. So when you have that type of a situation, all right, person owes $200,000 in debts, they only have $20,000 in their estate. There's a problem there. You can't pay everything. So there's a statute in Pennsylvania that sets forth the priority of payment. And it's important for the executor or administrator only to pay bills pursuant to that priority when you have an insolvent estate where they can be held personally liable. So the first things you pay are the costs of the administration. That means opening up the estate and the estate expenses. Then there's a family exemption that goes to a parent or a child who is living with the decedent and helping take care of them. They're entitled to $3,500. That's deductible. Then funeral and burial expenses, because the state wants to encourage people to be buried. Then medical expenses incurred within 6 months of death. Then a grave marker. Then rents for 6 months prior to death. Then claims by the Commonwealth and political subdivisions, and finally all other claims, which usually ends up being a credit card debt, so you might not have to pay them if you don't have enough money. Good. Okay. So this is very important just to know how to what the order is. The executor or administrator is entitled to a commission or a fee for the work that they have done in administering the estate. Because while it is an honor to be appointed as an executor in the will, it's a lot of responsibility and it's a lot of work sometimes, and so we're certainly entitled to take a fee. It is usually based on the value of the estate. They can choose to take the whole percentage, they can take a part of it or none of it at all. They are not required to take it. Taking a fee is subject to income tax by the administrator or executor because it's a fee that they're getting for the work. There can be attorney's fees, which are also paid out of the estate or to work with the executor or administrator. And that can also be calculated based on the value of the estate or on an hourly basis, depending on what the lawyer's going to charge. Now, people are always concerned about real property. That's your house. For many people, that is the largest asset that they own, and that they want to make sure that that's going to go to the people they want it to go to. If a property is jointly owned with another individual, the property can pass to them by operation of law and they are not part of the estate. If it is titled as joint tenants with right of survivorship, that is magic language on the deed, or between spouses, it's called tenants by the entirety. It means the husband and wife own the property or the spouses own the property together. And the property then passes automatically to the surviving owner or spouse. They do not have to get a new deed and they don't really have to do much of anything. They inherit. If the surviving joint tenant is a brother or a sister, there will be inheritance taxes on the part of the house that they have inherited. If it's children, same thing, inheritance tax. Now, if property is owned as tenants in common, which is another form of joint ownership, then the property passes pursuant to the will or to the intestate heirs. So that's why if you have a deed and you think you own property with someone, you want to read what it says and see how you own that property. If property is going to be passing through probate, then a new deed needs to be prepared, filed in the county where the property is located to show the transfer from the estate to the new owner of the property. And I will tell you that in many counties in Pennsylvania, there is property that is still owned by grandmother, even though grandmother died years ago. Child has since died, and now the grandchildren are living in this house, but it's not in anybody's name that could sell it, take out a mortgage against it, or do anything. So it's very important if you're living in a residence to just see how it's done. Now, if the decedent owned property, like a campground in Ohio or something, or Deep Creek, Maryland, or whatever, there's no Pennsylvania inheritance tax on property owned in another state, but you do have to have what's called ancillary or secondary probate in that other state to deal with the transfer of that property. So if you own property somewhere else, again, you want to plan ahead to deal with that. Okay. All right, now, when all the property's been transferred and everything distributed, we file a status report with the registrar's office to indicate that the administration is complete. If the administration, like let's say you had a piece of real estate that you wanted to sell and you couldn't sell it, it was in an area nobody wanted to buy it, every 2 years you have to file a status report with the register of wills to let them know what's going on with the estate. Most estates will be complete. But if it's not, you have to file something and say it's not complete because we still cannot sell this piece of property. And again, this is a statewide form indicating if the estate administration is complete. And if it isn't, and then it talks about some other questions about what you did to close out the estate. When an estate is closed in Pennsylvania, it is usually done one of 3 ways. The first way is through what's called a family settlement agreement. This is where everybody in the family gets along, the estate is solvent, there's no minors involved, there's no incapacitated people. And everybody can agree as to how we're going to divide the money or the property, and we put this together, it's signed off by all parties, and then distribution occurred. In some estates, you have an insolvent estate, and all the creditors won't agree, oh, you're going to pay us 10 cents on the dollar, we're not happy with that, we want more money. So sometimes you have minors in the estate who cannot sign papers, or you have an incapacitated person who's under guardianship in the estate, or you have family members who, lo and behold, don't get along. Believe it or not, that can happen. And they won't sign off because we don't think Bobby did a good job, or we think Bobby took too big a fee, or we think whatever Bobby did, we didn't like it, we're not going to sign. So we file an accounting with the court, the orphans court, who handles decedents' estates. And it goes to what's called an audit, which means it's reviewed by the court. And if you object to things, you can file objections, and then it will eventually go in front of the judge, and the judge will have to make a decision. There may be a hearing, things like that. It's more expensive, and most of the time attorneys will not do that unless there's a reason to do it, because there's problems, there's minors. Okay. The third way an estate administration can be completed is if it's a small estate under $50,000, you can do what's called a small estates petition and complete the administration that way. So, you know, and as I say, most of these estates, you know, will take anywhere from 15 to 24 months. And where do I get the number 15? Well, you have 9 months to file the inheritance tax return or the inventory from the date of death. It takes the Pennsylvania Department of Revenue approximately 6 months to review it. 9 plus 6 equals 15. Okay. And you can't make the Department of Revenue do things any faster. They do a great job, but they do it during the time. Okay. So now we have administered the estate. And now, if you have any questions.
We have one from the chat.
Okay.
If a death certificate is not in English, what do you do?
If the death certificate is not in English, well, first I wonder why you're opening an estate here, because normally here things would be in English. If they died because they went on a vacation to China and they happened to pass away while they were on vacation, they are still a Pennsylvania resident, they live here, say, in Allegheny County, you would probably have to go to some place like the University of Pittsburgh or Carnegie Mellon, get a translator, and pay to have the death certificate translated. Because if the Register of Wills office can't read it, they don't know who died, where they, when they died, where they died. So I think you'd have to do it that way. Okay? Because sometimes that happens, people go on vacation and they die. Okay. Usually it's more likely though that you would have somebody who goes on. I go down and visit my cousin in Maryland, and I'm, you know, eating a crab and I choked to death and I died there. And my death certificate is issued in Maryland, but I still live here in Allegheny County. I was just down there for a long weekend and didn't have a good time. You know, crazy things happen. So this process, as I say, it can be difficult. Sometimes people are afraid to deal with the state because of the Pennsylvania inheritance taxes, but it doesn't get better if you delay. The taxes are due within 9 months. If you don't pay the taxes within that period of time, then there's interest and penalties that can accrue. And sometimes, like we have in the state now where nobody did anything for 12 years. The actual interest and penalties on the inheritance taxes are higher than the inheritance taxes themselves, simply because they waited too long. So even though it's hard for people to deal with someone's passing, it's sad. It's better to try to deal with it and get things accomplished so that you don't end up leaving problems. The situation where the grandchild is living in grandma's house and nobody ever dealt with the grandma's estate or the parents' estate. Again, you're going to have to go back and open grandma's estate, pay the inheritance taxes. There's going to be inheritance taxes then from grandma to the child, and then from the child to the grandchild. And you know, there are some programs around title programs that are through the Allegheny County Bar Association to try to help people resolve some of these issues, because it is fairly common actually here, especially now in Allegheny County and in different places. And we do try to work on that because you want people to be able to own their home, to be able to sell their home, to be able to get a mortgage if they need it. And you can't do those things if you don't have title. Other questions? Yes.
You sound like a silly question, but do you consider, when you say property, are you also saying like a car or a snowmobile or a canoe or whatever?
Yes, when you're talking
Not
about
just houses.
so yeah, when you're talking about property, you are talking about things like vehicles, boats, snowmobiles, because those all have titles, right? And you can't just say, oh, well, you know, my mom died and I'm going to just start driving the car. You need to get the title transferred. Now, sometimes if you're an only child and you have a will that says everything is left to you and there's no other assets in her name alone except for the car, you could take the title to the car. You could take a death certificate, the will, go to the AAA, something like that, and they would have you sign appropriate paperwork. However, if you have you and two brothers and your brothers won't sign the paperwork, then you're gonna probably have to open the estate to transfer the title. Okay? So, but personal property also includes things like your clothes, your jewelry, your dishes, your electronics, yes. Oh, and that's one of the other important things is that since so many people have a lot of information that's online and there's no other way to access it, sometimes if you're the executor or administrator of an estate, you may have to get permission from the court to get the Google password so that you can get into their Gmail account or to get it from other places as well. This is something that's just come up in the last year or two. That's when Pennsylvania finally passed a statute having to deal with digital assets and digital accounts. But it's still a difficult process and it takes a little bit of time just to be able to access that information. Or to be able to get their photos off their phone. If you don't have, remember, it's like a phone, let's say it looks at their face and that's what opens up the phone and their face isn't around anymore. You laugh, but these things happen. So, yes, Ms. Lee, anything else? Yeah.
Are there any special considerations if your executor lives in another state?
Are there any special considerations if your executor lives in another state? It can be, but now with virtual probate, it does make it easier to get them sworn in. They have to provide information, and this is where it might be helpful to work with an attorney as opposed to just going to the Register of Wills themselves. Because you have to provide the original will, you have to have your driver's license, you have to sometimes have to get them bonded, it just depends. And so, but you have to go through a few more steps, so it usually takes a little longer. If somebody can walk into your office with the death certificate and the original will, most estates can be opened up in most counties in a couple of hours, pretty quick. Pennsylvania does estate administrations pretty well. One of the things we're good at. So that's because we have the second oldest population in the country to Dade County, Florida. So we're good at that. But they can do it, they can get sworn in. They have to have somebody to do things though. If somebody needs to clean out your home or get your house on the market, those are things that it's hard to do. But a lot of times people do have executors who are out of state. And that can work. Don't not name me because they live out of state.
I have a question. What if an estate is administered and a bank account is later found to have been in someone's name?
Okay, what if an estate is administered and the bank account is found later in the decedent's name? That can happen quite frequently because now that Pennsylvania has all this unclaimed property out there. So if you haven't looked for yourself in your own name or any of your family members' name, it's a good thing to do. So sometimes you have to basically get a new short certificate from the registrar's office and submit the paperwork, and you may have to open up the estate again. I mean, what if the bank account that nobody found, because nobody really knew it existed, had $80,000 in it? You're gonna have to pay more inheritance tax, right? And so you have to do that. But that does happen actually quite frequently. So it's a good thing if even just check for yourselves, because you may be surprised to say, oh, look, I have a little check under $100, and it's a refund check that you never cashed, you never got. Okay. Anything else? Yes.
Of course, this is on my mind because I'm getting to that part that should have a will like how I don't. But anyway, I have some possessions that I don't think either of my daughters are gonna want, such as the type of dog I have is the Senji. And I've collected the Senji pictures and figurines and whatever. I'm thinking about donating those to the Senji Club of America so they can auction them off. Does that still have to be valued somehow or no?
Okay, so if you had certain pieces of personal property that is value to you, but nobody in your family wants them, I believe me, this happens quite frequently.
Sure.
So you might in your will want to have a specific request of those items to the Vicente organization. And you might have to put in your will that you would want to have the estate pay the cost of shipping all these things to them wherever they are.
Okay.
So yeah, you probably want to do that. And some people, if they have dogs, and they sometimes put pet trusts in your will to make sure the dog itself, or the cat, or the horse, or whatever it is, taken care of after they die. Okay? Yes, ma'am.
Could you explain a little more about what an estate would be that did need probate, because that's kind of easy to, I thought everything needed to have.
Oh, okay, so no, an estate doesn't always need to be probate. So basically, people who die and they don't own anything, there's no estate. People who die who only have joint assets, all right? So some people will put their assets in joint names with children or their spouse or other relatives. They won't need an estate. There will still be inheritance taxes due, but you don't have to open the estate because the joint assets pass by operation of law. And the same thing with assets that have beneficiary designations, retirement accounts, and life insurance policies. Okay, you can do it on brokerage accounts as well. But those still, again, are going to be subject to inheritance taxes. So somebody's going to have to pay the tax if there is no estate. Okay, so that happens with a lot of assets. But still, most of the time, if people have a piece of real estate, that's when we often need to have an estate, because we don't usually want to put other people's names on your house or your condo, because if you want to sell it, now you have to share the money with them, or they have to agree to your sale of it. It can make it a lot more complicated. So don't do that. Don't put other people's names on your real estate or on your bank accounts without having a discussion with somebody about what it means. Okay? Okay, well, it's been lovely. Thank you all for participating, and it's been very nice. Please plan ahead. Much better to have a will than it is to die intestate. So you get to decide where stuff goes, not the state. Thank you.
Thank you.